We're still on the campus of Wake Forest University in North Carolina, the home of the Bowman Gray Medical Center, to continue our exploration into the nature of the health crisis. And today we want to probe the question, is there a point at which old people should be permitted to die? Stay tuned.
This program is a Warren Steibel production in association with South Carolina ETV. Funding for Firing Line is made possible by a major grant from the John M. Olin Foundation, Incorporated. Additional support is provided by the Annenberg Foundation, the Laurel Foundation, and the Friends of Firing Line.
A few years ago, you may remember the governor of Arizona who contended for the Democratic Party nomination for president let slip that old people should be permitted to die. That statement created an uproar but was insufficiently examined until now. Professor Mark Hall teaches both at the law school here at Wake Forest University and at its medical school. His subjects are law and public health. He's a graduate of the law school of the University of Chicago and the author of several books. Dr. William Hazard, who graduated from Cornell, is with the Department of Internal Medicine at Bowman Gray School of Medicine here. He was a staff physician in the Marines and has taught at other distinguished universities. Professor Charles Longino is a sociologist who teaches at Wake Forest University. He has degrees from Mississippi, Colorado, and the University of North Carolina. Let me begin by asking Professor Hall a legal question. What, if any, are the laws of North Carolina touching on our question? Is the state required to provide what goes by the name of heroic therapy?
Well, that would be decided under the criterion of medical necessity, which is the terminology that's employed in standard insurance contracts as well as in Medicare and Medicaid programs. And it's an interesting concept. Necessity suggests providing only services that are essential, but in fact, the way the term has been construed, the technology that makes a procedure possible means that we want that procedure and our wants become our needs, and so necessity has been construed in a way that says that physicians must do everything that can provide any conceivable medical benefit regardless of the cost, and that is the current legal climate not only in North Carolina, but throughout the country. A wonderful instance of that is the case from California that was in the news a couple of weeks ago about the woman who died from breast cancer. The insurer refused a very expensive intervention known as bone marrow transplant on account of its experimental status, but the court and the jury ruled that it met the criterion of medical necessity and therefore awarded an $89 million punitive damages verdict. So that's the legal climate that compels heroic measures in all cases.
$89 million. Mm-hmm. That's kind of exorbitant, isn't it?
It shocked everybody, I think.
Yeah. Well, suppose we start at the easy end. Some medical resources simply are insufficient to meet demand, in which case one has to give preference to somebody, right? Say, dialysis, am I right? That stuff is hard to come by, isn't it? I'm told that in England, if you're over 55 or so, you just don't get access to dialysis. Is that correct?
That's true, but with important and, I think, informative exceptions. In England, basically, over age 60, it is presumed that you would not benefit from dialysis. Mm-hmm. However, the records show that individual exceptions are made, and they have to do with political connections, position in society, and sort of access to special avenues of care. So even there are other considerations. But yes, dialysis is expensive. It has long-term implications, so the cumulative cost is substantial. In this country, age is not a criterion for beginning or in any way sustaining dialysis.
Now, is that mixed up in any way with the Civil Rights Act that forbids discrimination against somebody on account of age?
no doubt that's a societal judgment that, yes, it is mixed up.
Now, isn't medicine walking into a situation in which it will almost certainly devise terribly expensive technological forms of relief, in which case there's a rationing aspect built into the situation? When that happens, what would the political picture be, say in North Carolina, on who has a priority in having access to such medicine?
One of our difficulties is, in point of fact, that era is already here. We already have those technologies. They're widely available. What is clear, however, is that age is the poorest criterion one might have for the application of those, because they are being applied already more toward the younger chronically and desperately ill than they are toward the most elderly chronically and desperately ill. So what we have is an overall requirement and expectation for very high technology, very expensive care, which is now being probably informally rationed or allocated with age as a secondary or a tertiary criterion, and perhaps being done reasonably well.
Which is the governing agent in making that decision? The patient, the hospital board, the state, the attorney general, who?
Well, I think as Mark indicates, there are legal precedents, and there are sort of practical or applied precedents. In point of fact, if you define it legally, there is only one person whose opinion or whose goal is of consideration, and that is the patient's. And there are no rather formal criteria and steps you can go through to define that. However, in a practical case, if the patient is incompetent, if the patient is in coma and can't communicate and hasn't given an advance directive, then it falls to the family. The physician in this position is that of advisor, counselor, giving best medical advice, trying to apply some common sense. But as you imply, there's an awful lot of conflict of interest and conflict within the profession over this.
Well, let me ask, Ms. Longino, a while ago on this program, I guess it was 4 or 5 years ago, Malcolm Muggeridge was my guest, and I said to him, because he had written a very strenuous and mobilizing essay opposed to euthanasia, that under no circumstances would he decline treatment, except, said he, if the resources had to be either his or that of a younger person, in which case he thought it correct, with reference to natural law and priorities, to yield to the younger person. Is this an ethical question in the course of consolidating as a straightforward philosophical question to be put to democratic people?
It's certainly an ethical and a political question in the context of a family. And Malcolm Muggeridge is quite right that most people in their later years approach the issue of death with one eye on what it will mean for the finances of the family, especially the younger generation. And they require some assurances. That is, the children should assure the parents if the children want to make all of their resources available. But the point...
But I thought Mr. Hall said that under the laws of the state has to come through no matter how expensive the medicine is.
But there's an autonomy principle here for the patient, and that is the patient can decide in terms of an advance directive what they wish should happen.
By simply declining the treatment?
Yes. And this needs to be discussed within families.
Yeah.
And what I'm saying in that political process of discussion within families, the older person wants to be assured that that whatever happens to him or her is not going to impoverish the next generation in the family. And those things have to be discussed.
Well, let me just get one thing straight. Mr. Hall, do I understand you to say that the state of North Carolina has to make available the medical resource required, or you're saying, sure, but they can build a family for it?
Well, the legal climate I described, first of all, is not unique to North Carolina. It is pervasive throughout the United States, with the notable exception of Oregon's scheme, which has not yet taken effect. But the source of the law for the federally funded programs of Medicare and Medicaid would be the federal statutes. The source of the law privately would be the terms of private insurance contracts, which are regulated by state insurance regulators. But so if we want to change that climate, the question is how do we go about doing it? And I think your question as to what agency, what mechanism of society we use is exactly the way to look at it. I'm writing a book for Oxford Press that asks exactly that point. And my way of approaching it is to say we should ask individuals, and we should ask them in a framework by which they're making an intelligent insurance purchasing decision. So if we had a variety of different kinds of insurance that had a variety of different kinds of criteria, defining medical appropriateness in more or less generous ways, then people could make intelligent spending decisions and purchase insurance that doesn't cover expensive heroic measures when they're virtually futile, and save money on account of that and have that available to spend elsewhere. You asked the question in terms of trade-off between young and old. That's thinking about the problem at a point in time, but I think we need to think about the problem over a single person's lifespan. So a person when they're young may choose to purchase insurance that is not quite as aggressive at the point of serious illness, whether that occurs when they're young or whether that occurs when they're old, so that money is available for other uses in life, such as education or pure hedonism. But in making those choices available, we obviously have to make sure that we limit the range of opportunities, some prudential constraints, because people don't have full cognition of what it's like to be confronting death's door and wanting everything possible, and we have to be willing to offer choices that we're willing to enforce or live by the limits if people select them. If we're not really willing to live by them as a society, then we ought not to fool ourselves.
Well, you say that these laws are quite quite general, and one shouldn't speak of North Carolina law, but aren't there very considerable differences in the living wills of different states? Or are there?
Yes, although with passage of time, less and less. I think we're coming more toward national consensus on what constitutes a living will. May I say one thing which I think may illustrate my earlier point? For instance, the patient that you referred to, the lady with the bone marrow transplant, how old was she?
She was, appeared to be in her 30s or 40s.
Precisely. The major high technology, very expensive medical procedures are not being applied to the very oldest sickness. They're being applied to people for whom 30 or 40 years of normal life expectancy might be there.
Yeah, I agree, absolutely. I read some estimates that said that if we denied all treatment to everyone who's 75 and older, we would only save 15% of our national spending. And
are we dealing with noblesse oblige, or are we dealing with the law in matters of this kind?
Noblesse oblige, noblesse familiae, or whatever you might say. These are very personal and family issues. I'm not sure that it's a class issue, but there are certainly class elements in how medical care is distributed.
Well, since you're probing out with statistics, do you have any statistics for the number of people who don't get that effusive final treatment for economic reasons over against those who don't get it because they elect not to have it?
Well, right now, I don't think economics plays much of a role at all. I think there are those who don't have insurance, the 15%, the 37 million, or the 54 million, depending on the numbers, and they fall upon the hands of hospital physician charity. And nobody's done a good study as to what kind of treatment they receive in these life-ending situations. For others, I think that people are now free and enjoy this freedom, and I think it's a valuable one, but it's an expensive one, to execute living wills or not without thinking very much about the cost, the financial cost. I think the primary burdens that are thought about now are the emotional burdens, and I think it's appropriate that people also think about the financial burdens.
But now, a living will doesn't really work, does it? Unless you're kind of knocked out, because you can always revise it. I mean, can't you? If you become sort of comatose, then the living will is very useful. Well, otherwise, you say, well, I've thought it over.
That's true, but it works precisely because it is revisable. It's a living document. It's always revocable unless you become incompetent or uncommunicative. And that's where it's most useful. for the physician and the family and the patient to negotiate on an ongoing basis what they really want. So what you want at age 30, what you want at age 50, what you want at age 80 is probably going to be quite different.
Right, right. Well, where you have, say, a patient who is ambiguous when asked, do you want to submit to an XYZ, which will cost $1 million or whatever, and the wife says, she interprets his answer saying, yes, he does want it. You, as a doctor, interpret it as he doesn't want it. Who prevails?
If the patient is competent and communicative, the patient always. If he is ambiguous, then you must interpret it, and if you can communicate, you must pursue that to get a sense of what the patient would want.
Well, is there a monstrous liability building up with the wife saying, give him the stuff, and you saying, no, I think he doesn't want it?
That's a point where people become very uncomfortable, because which physician is going to withdraw or apply a different technology when the closest of kin says no, they want something different? It's a very, very difficult position to be in.
See, and this gets back to the point that I was trying to make earlier, and that is the negotiation really has to take place in the family beforehand.
Yeah.
And when older persons especially are in the hospital, but not only, they need advocates. They need family members who are going to advocate for their interests in case they can't talk.
I know, but the perspectives by which one's interests are judged are constantly changing, aren't they? That is to say, at 30, you can say, well, I don't want anything, anybody keep you alive past a certain age because X, Y, and Z. But as you approach that age, it becomes a commitment that's more and more attenuated, isn't it?
Well, as our attitudes toward death and our personal attitudes toward our own life change as we age, if these are clear to those that are around us who are going to be our advocates when we get in that situation, then it provides a lot of help for the physician.
I think if they change, they're more likely to change in the opposite direction. The older the person, at least in my experience, the more they accept the prospect of death, and the more they fear the prospect of being dragged out, immobilized, dependent, helpless.
Oh, so it's usually the dependents who egg the doctor on rather than the patient.
Indeed. And it may not be the most appropriate dependent. The classical instances, the son who flies in from California, who's a lawyer, who's the big deal in the family, and the daughter has been caring for mom forever and ever, and he may prevail simply because of family politics.
Intending nothing personal about Mr. Hall, to what extent is the law an enemy in artistic situations of this kind?
I think the law is a collaborator at best. And I think here at Wake Forest we have a very collaborative environment, so we can speak very positively.
Other than at Wake Forest.
I understand. There are the classical lawyer-doctor jokes that are out there, we understand.
And the people who get $89 million in judgments.
That doesn't make anybody feel good except maybe one person or one family.
I have to speak up at this point. I'm a lawyer. I'm here to help you. And I think this is one instance where the law has led the way in a positive, very positive way. I think it's very clear, looking historically, that the medical establishment was very reluctant to honor patient requests to not resuscitate or to withdraw feeding tubes, and it took the courts to force the medical establishment to comply with patient wishes, and I think that has led an attitudinal shift. In fact, the complaint now is that the pendulum is swung too far in the other direction, that now physicians and hospitals are insisting on withdrawing treatment because it's futile, under their definition of futility, even though the family wants to continue treatment, and which shows you the depth of the attitudinal shift that I think was all spearheaded by cases like Quinlan and Cruzan. So the interesting question to me now is this futility notion, which is where families and patients want to continue in the medical establishment, the physicians and hospitals.
But futility becomes the operative word. What does futility mean? Well, if somebody simply wants biological survival, do you consider that futile or not? I mean, I would, but Mrs. Jones might not.
Well, that's the point. It's a value decision, not a medical decision. The medical criterion has always been bodily functioning. I mean, with degrees of, obviously, quality of life and what have you, but I think it's somewhat camouflaging a social value judgment and attempting to incorporate that as a medical judgment to appropriate the futility concept in some of these circumstances. Now, to say that is not necessarily to say that it's wrong. because I think that there is some value to incorporating some prudential constraints, resource-based constraints, in medical standards. And I think it's appropriate for physicians and hospitals to say, this is simply too extreme. We don't think it's socially responsible to behave in this way. And if you want a doctor to do this, you're going to have to find another doctor. Maybe futility isn't the best word to describe that, but I think it's an appropriate attitude to take as long as we're open about it.
Do that under medical ethics? A lawyer at a critical point in a proceeding can't withdraw, can he, legally?
That's right. The whole point is...
Can a doctor withdraw?
Not at a critical point, but a doctor could transfer. So the bind comes when there is not another...
doctor around.
Right, right. And so if it's at a critical stage, then that solution isn't available, and we come back to the core dilemma of whose values and whose interests predominate.
Well, let me ask, any of you wants to comment, is there a consensus developing that supplies some structure to the medical/ethical point of whether or not to keep a patient alive?
Hospice.
What is it?
Hospice.
Oh, yeah, well, that's if you're dying, right? A hospice is just a nice place to die. But I wasn't talking about that. I was talking about whether we are approaching a point at which people are expected to give up rather than to prolong life because they want to prolong life. Is that happening?
I think what Chuck is saying is that hospice is a humane and rational alternative to the denial of the dying process. I think what makes most sense when we teach medical students is the common sense approach that you don't want to prolong the dying process. You don't want a process which is natural and normal and part of our biological gift to be prolonged without some positive benefit. And if it's only negative, which is suffering, then you need to allow it to take place. What we have not done, unfortunately, is put in place a very powerful establishment to provide alternatives. Hospice is a positive alternative, but it's not been supported or allowed to flourish to the extent that it has in other countries like England.
Yeah. Well, hospice is administered medicine, of course, but it's certain kinds of medicine. You never expect to leave a hospice. We know that. But while you're there, they do something besides give you cornflakes, don't they?
Yes, they provide or maximize comfort, minimize pain. They provide alternatives to allow you to make the most of the quality of the life that's remaining without trying to prolong it in a futile manner.
But they wouldn't give you chemotherapy or anything like that?
It would not be incompatible to have a patient given chemotherapy who is on hospice. It depends on the quality. If the chemotherapy prolongs life of quality, then hospice and chemotherapy would be additive in their effects.
The problem with you intellectuals is you individualize every situation.
Dr. Longino and Dr. Hazard and I were talking about this a couple of days ago, that one senses a need for an institutional environment in which a patient can go who doesn't want to declare that they've given up, but on the other hand doesn't want the most aggressive kind of treatment, and one that provides caring, supportive treatment, perhaps with the expectation that death is ultimate, perhaps not. But I would think, I mean, you might want to speak to this, that hospice is adaptable to that. I mean, there's certain, hospice grew up to meet a certain defined institutional need, and it's, I think, capable of expanding to another need.
It's been supported by Medicare dollars since the Reagan administration, partly because of the AIDS epidemic.
Mm-hmm.
And
AIDS epidemic? Nice formulation.
Well, epidemiologists study AIDS. The hospice, like any other part of the medical establishment, will evolve depending on resources and needs and values and perceptions and politics. And it's conceivable that it could reach down a little bit to capture those who are not within 6 months of death or want to be away from some of the tubes and invasive kinds of therapies and treatments.
Well, as a practical matter, do you frequently or infrequently run into a situation where the healthy member, the wife, let's say, urges you on to take measures which you reasonably suspect the victim would not himself take, and which you wouldn't recommend?
I would think that would be very unusual.
Unusual?
Unusual in the first instance, perhaps evidence of a dysfunctional marriage or a relationship where they hadn't talked about these things and they weren't mutually supportive. Couples need to share this as well. That comes up very uncommonly. On the other hand, what is much more common is they may not have thought about these things. So the physician is often a position of negotiating on behalf of the family and the individuals to try to close those communication barriers. The adamant saying, no, my husband wants this and it's absolutely essential and you must do it, is an extreme and irrational position. In my experience, it's only been irrational people who have advanced that.
But people are most characteristically irrational when their beloved husband or wife is dying.
There are forms of irrationality. It doesn't go as far as say you got to keep this person alive.
Well, thank you very much, Professor Longino, Professor Hall, Dr. Hazard, ladies and gentlemen of Wake Forest University.
Next week, on the last of a four-part series that puts health care on the firing line, host William F. Buckley Jr. talks with Dr. Sherwin Newland, Dr. Burton Reifler, and Mark Hall about whether physicians should help those who want to die. This program was a Warren Steibel production in association with South Carolina ETV. Funding for Firing Line was made possible by a major grant from the John M. Olin Foundation, Incorporated. Additional